Mr. Chair, we're in public session.
Thank you. Good morning, everybody. Welcome to the November meeting of the Joint Commission on Public Ethics. Let's get right down to it. We need approval of the minutes from our October meeting. That's at attachment A. Can I have a motion, please?
Moved.
Thank you. Second. Thank you. Second is Weissman.
Okay.
All in favor?
Unanimous in Albany.
Okay, unanimous here also. And we have Marvin. Thank you. Item 3, report from staff. Seth?
Just as an update on some on outreach activities, our trainings through our education staff continue at a very fast pace, particularly those that need training who are FDS filers. That's moving along. This coming December, there's the annual meeting of COGL, the Council on Government Ethics Laws. Correct. Our directors of training, directors of education and ethics will be, of lobbying and ethics will be attending that on behalf of the commission. Additional outreach coming up in January. I'm going to be speaking to a group in the City Bar Association. I've been asked to talk to them about various ethics-related issues, and both Monica and I were asked by a group of the NYU Law School faculty to address some faculties and scholars in a session about JCOPE ethics and other ethics issues. We have a fall-winter newsletter coming out shortly. And we also have our ethics reminders, which are short pieces on very short, very cogent, practical pieces of advice that we distribute to the state workforce, and those are being worked on as well. I think that about covers the update on those activities.
As a matter of Seth, hold on one second.
Sure.
Go ahead, and then I'll jump in.
A three-part question. What date is the NYU event? Is it
That's my
open?
question.
Oh, is it open to public or commissioners? And is it at the Brennan Center or at the law school?
Three wonderful questions, Commissioner, and I believe it's going to be just a discussion in the faculty lounge with faculty and scholars that have been invited to have that session. So I don't think it's, to my knowledge, it's not open, but I'm sure if I asked if some commissioners would want to attend as well to be there, I can't imagine whether that would be why that would be an issue. So I'll let you know the date. I don't recall the exact date now. I believe it's in February, but I don't recall, and it is in conjunction with the law school, not the Brennan Center.
Great. So why don't you circulate that date to us when you have it?
I will do that.
Okay, thank you. Next.
On the leases, Monica?
Sure. This is an ongoing project. We are in. Our leases are coming up in both our Albany offices and this office in New York City. We're working with OGS. They're negotiating with our current landlords as well as considering other options. For Albany, we stress that it's important that we stay, downtown, but outside of the agency buildings. That we need a storefront entrance for people to be able to come in, and we need a hearing room. In New York City, so we're considering and working with our current landlord. They're negotiating with them, as well as 2 other locations. We're hoping for an update soon. And then decisions will be made relatively soon, but it's a long process to get the space ready for us and before we move. So I think our leases are up, Steve, at the end of next year?
Pretty much April 1 for Albany, and I think, yeah, you're right. A little later on the road.
Okay.
In New York City.
Is that 18 or 19?
Is that 18? Yes, Steve. Is that April 1, 2018 or 2019? Yeah. Everything is coming due in the next year, so.
Yeah, I think it's 19, but I will keep you posted as we have more information.
Okay, thank you. Item 4, regulations. Before we get started there, I have a statement that I'd like to read. Apparently, there's been some confusion about the status of the Commission's lobbying regulations, which currently are under consideration. I want to be very clear. The Commission is in the middle of rulemaking to develop and adopt regulations which will have the force and effect of law. The Commission has authority to issue these regulations and is the sole entity charged by law in New York with administering and enforcing the Lobbying Act. The Commission has implemented this rulemaking process to inform lobbyists, their clients, and the public how the Commission will interpret and enforce the Lobbying Act. Failure to follow the regulations, which detail how the Commission interprets and applies the law, will constitute a violation of the Lobbying Act and the regulations. Violations of the Lobbying Act and the applicable regulations thereunder will result in the imposition of penalties as provided by law. The Commission will pursue such violations to the full extent permissible under the law. These regulations are the product of a transparent and collaborative process. We have solicited input from the public at every step of the way and will continue to do so. The Commission's goal is to provide a comprehensive and straightforward set of rules for the regulated community to follow in order to understand and comply with the requirements of the Lobbying Act. With that said, I'll turn the discussion over to staff to address some of the specific issues that have been raised in public comments and at the October hearing. Thank you.
I'll take that as a lead-in on some of the substantive issues. There are, as you know, a number of substantive issues that were raised in testimony and in the written presentations that we received. Staff is in the process of digesting it, making proposals for the Commission to consider. We thought we would take and ask, and this is going to be without a vote, but make some presentations on some of the issues that were raised at the hearing and in the writings. Not all of them. We're going to address a good number of them in December as well. But the four issues that we were going to just toss up and do presentations on for the Commission today are the following. Issues relating to reportable business relationships, commission salespersons, social media, and the reporting requirements of coalitions. As you know, those are four of the perhaps 10 major issues that have been raised by the comments, and we thought we would parse those out for you, and if it engenders discussion or feedback, that would be welcome. We hope to have a markup based on input from the Commission by the December meeting, red line copy, digesting your comments and suggestions and further work. So between our Director of Lobbying, Andrew, and Carol, our Deputy Director, they'll do up some presentations. So I think I'll tee it up with Andrew to talk about reportable business relationships first.
Thank you. So based on comments received and some further analysis, staff is suggesting some revisions to the reportable business relationships section to clarify specifically when a client organization should disclose reportable business relationships related to its high-level members.
What's that section?
Reportable business relationships are
43 what?
14. So the regulations define who may be a high-level member of a client organization in situations in which the client filer should be disclosing reportable business relationships over which the high-level member may have substantial control. In some situations, if the high-level members have an RBR compensation situation related to personal business, that will be disclosed by the client filer. So we can, that's reportable business relationships. So we move on to commission salespersons unless there's questions or discussion.
Okay, let's keep going.
Just the commission salespersons, if you're looking at the rules, just we'll head that off anyway. I believe it's 943.8 C2 in the it's in the procurement lobbying section where there are exceptions dealing with commissioned salespersons. Is that the, I believe
That's correct. The definition of lobbying provides for a number of enumerated exclusions, but one of which is an exclusion from the procurement lobbying section for those persons who are commissioned salespersons as defined in the statute. So this will spell out some of the criteria for meeting that exception.
And as Andrew will explain, this is something that was raised by a number of entities and individuals that have commented on the regulations. So, Andrew.
So there was a number of comments related to a percentage of a mandatory annual compensation threshold. So we're changing that and are going to shift it to a different concept or perspective. So a person will qualify for this lobbying exception if they're receiving a sales commission on at least 50% of the number of sales that person has made. So that's a variation from what was in the previous draft regulations that were, the revisions address the concerns raised at the October hearing and provide some additional clarity and definition concerning the statutory language, quote, all or a substantial part of the sales which the person has caused. And part of the regulation goes through the several components of what it means to be a commissioned salesperson, but we tried to attack the area where there was a great deal of commentary and shift the concept.
Just to clarify, the idea here is that when we initially approached this issue to provide some indicia of whether someone was a regular commissioned salesperson, the original draft regulation stated that the person had to show that at least 50% of their annual compensation came from commissions. Comments were made that left folks who had a hybrid compensation arrangement where some of it was base salary and some of it was commission in a position of uncertainty where they wouldn't know till the end of the year whether or not the commissions made up half of total comp. So what we did in acknowledgement of this issue was say that it's not about the amount of the sales, it's about that the number of sales carry a commission, whatever that level is, from points on the sale to a flat amount per sale. But the idea is at least half of total sales must carry some form of commission. And this is, I think, a better indicia of whether someone is regularly a commissioned salesperson. And will remove the uncertainty of what happens at the end of the year.
But my understanding, we're not making that a bright line rule. That's a per se determination if 50% or more of the income is derived from the commission, from the income based on commission. But it's my understanding, is there a possibility if you earn less than 50% to make an application as a commissioned salesperson? My understanding was that we weren't saying you had to have at least 50% of your income, but that if you do, it's a per se qualification as a commissioned salesperson. Am I wrong?
I just want to tweak that just a bit. The statutory criteria, in addition to being a commissioned salesperson, are that you have to be retained on an employment contract of more than 6 months. You have to provide that your state contracts don't carry a higher commission than your non-state contracts. There's a couple of others, but the point is that this was one of those criteria, and that the 50% of total compensation would have been a per se or a prima facie case of meeting that factor. What we're saying now, obviously, is to tweak that level of compensation to number of sales, regardless of the amount of the commission. But again, it would only relate to that one single factor in the analysis. We have it drafted as a strict criteria to meet that factor, but one of the options that the commission could consider is that it is 50% is a per se qualification, but there can be an ability to apply for some sort of extenuating circumstances or otherwise a substantial showing that this person is intended to be a commission salesperson. But as drafted, it would be a strict 50% criteria.
I see that as somewhat problematic. As a commission salesperson, and we have the reporting obligations quarterly going forward, can someone determine what their year-end income is going to be and the percentage of income derived from commission sales in the first, second, third, and fourth quarters of the year, not knowing what the end of the year brings? So I have a significant concern of specifically limiting the commission income to 50%, where I would assume in most situations that the actual percentage of income, unless somebody is a 100% commission salesperson, and we heard through testimony that that may or may not be the case depending upon the industry and the practice. So if somebody does have 50% or less than 50% of commission income, I would think that based upon the statute, the opportunity would still be there to be either apply for or make an application to be considered a commission salesperson.
Commissioner, your point is well taken, and in fact, that is the exact reason that we are proposing certain revisions to avoid that situation. And those revisions remove that threshold based on total compensation. It's rather a threshold based on whether or not any sale carries a commission. You should, I would think, but we always welcome comment, you might know ahead of time whether or not each of your sales will carry a commission, whether a sale is a commission sale or otherwise. There is obviously a smaller element of uncertainty, but that said, I think your point about having a way to meet the criteria without a strict standard, or excuse me, without a strict threshold is something that we can consider. And if you'd like, we can bring that forward in December.
And we'll have some draft language, which is obviously fluid. We'll get you something concrete to look at on that as well.
Martin, just out of curiosity, do we have any idea of the universe of people that would be affected by this?
Unfortunately, we don't collect that data because it is an exception, and it's not something that needs to be applied for. It's something that can be claimed.
Yeah.
I think, one way to encourage comments is to, spell out these rules and try to determine how much feedback comes through. We can, the organizations that commented on it include the Business Council, which obviously represents a large number of members. And so we can presume that many of those members carry that concern, which is one of the reasons for the revisions. But unfortunately, because it is an exception from the definition, it's inherently not reported.
Okay, thank you.
Great. And we will have markups with everything we're talking about for your consideration before the meeting next in December. And this is the kind of dialogue we need, so thank you. Carol Quinn will pick up the topic now if we're ready to move on to social media and some of the issues raised by that were raised in our hearings and comments.
May I just,
I'm so sorry.
if I could discuss, Andrew was talking about 943.14 and reportable business relationships. During the course of the public testimony and the comments received, I believe that this correlates to 943.4A2, and that is the provision that if a lawyer was providing legal services to a client and then subsequently was retained to lobby on behalf of that client, that attorney would be responsible, as I understand, please correct me if I'm wrong, to disclose all of the monies received and legal work to some extent completed on behalf of that client. That is my understanding if they were acting as a lobbyist, but performing other legal work for the entity, that they would have to report the amount of money they received from the client for the other legal work. Is that true or not true?
Plainly, no, it's not, but I can spell out exactly why.
Okay.
First, we did want to avoid that situation. And the exclusion for these non-lobbying services is part of the statute, so there is an intent to exclude it. And so we were obviously bound to include that in the regulations. Your point about whether there was an additional relationship with a public official by that lobbyist, when, you know, perhaps in a non-lobbying, obviously in a non-lobbying capacity, a reportable business relationship is defined to include payments, or excuse me, to only cover payments from a lobbyist or a client to the public official. That transaction that goes in reverse, where the public official pays the lobbyist for services, would not be captured or reportable.
By definition.
By definition, it's a transaction between the same parties, but it's about the lobbyist paying the public official, not the alternative.
So if the lobbyist is paid by a client that he or she does legal work for, do they need to report the X number of dollars that they completed?
No.
Or that they received for the legal advice exclusive of the lobbying services?
They do not.
Okay. Thank you.
Okay, so as Martin discussed several months back, social media is used in many lobbying campaigns nowadays. So we do have sections that deal with the use of social media in both the direct and the grassroots sections. It's in 943.6C and 943.7F. We did receive several comments questioning an employee's personal social media activities and when is that attributable to the organization. So we're suggesting revisions that would clarify when an employee must be identified by the organization as an individual lobbyist, you know, by virtue of the employee's personal social media activity, when an employee's personal social media activities are attributable to the organization as far as like an expense, and how does the organization, how can they report expenses attributable to social media? So we're making some clarifications. We plan to for revision and to set before you on December 19th. So we plan to clarify and clearly state that the personal social media activities of employees are attributable to the organization, and that person must be listed as an individual lobbyist by the organization only if the activities are part of the person's job duties. And we also plan to add some examples maybe to further illustrate that point in the revisions. This clarification we're also going to carry through to reportable expenses. So, for example, right now the regulations provide that reportable expenses related to social media may include things like consulting services, staff time allocated to planning and posting social media messages, and promotion advertising costs. We're going to revise that a little bit to clarify that staff time allocated to planning and posting social media messages would be attributable to the organization, again, as an expense only if it's part of the person's job duties. So, in essence, we don't care about the personal social media activities of an employee, and we're not asking the organization to track those activities unless it's done as part of the person's job duties. And then the other clarification we're going to put in, we're going to suggest to put into the regulations is clarifying that the organization can, in good faith, use a reasonable methodology to try and come up with reportable expenses, to try and come up with some way to calculate staff time, for example, for lobbying via social media. So those are the revisions we're suggesting as far as social media. And again, we got several comments dealing with, you know, how can an organization possibly track the personal social media activities of its employees, and we're trying to clarify that point. If there's no other questions, I can move on to coalitions.
Well, are you at 943.6?
Yes.
As we're discussing 943.6, direct lobbying, I need to set forth my concerns in regards to the definition, subsection A, subsection 1, subsection F, in what I'll define as the billboard definition. I had a chance, again, prior to our meeting today, to review the written submissions that we received prior to the public hearing, and again, review some of the testimony, and I have significant concerns about this provision being included in these regulations. If it is at all described as it is here, I have serious concerns that this could potentially be violative of a number of federal constitutional rights. And I'm not sure how the other commissioners feel about this, but this public communications definition, attempting to define direct contact as it pertains to lobbying, does not appear to me to be an appropriate regulation for us to pass.
Commissioner, just your point is well received and obviously echoed or preceded by comments from the public. I just want to clarify that we will be taking on this issue for discussion before any vote at the next meeting. So it might be premature to bring it up today, but it is definitely the, if not the high point, one of the issues to be presented.
Thank you very much.
Okay, next.
Carol, we'll talk about coalitions and the reporting of coalitions.
So coalitions is at 943.9H3. And I'm going to take a little bit of time just to kind of go over coalitions again. I think that's important, just to reiterate that the regulations currently provide, and we're keeping this section at the moment, we're giving coalitions a choice on whether they file as a coalition or not. So currently, the regs provide that if a coalition expends or incurs over $5,000 in annual compensation or and expenses, so basically, if they meet the $5,000 threshold, they can either do one of two things. They can file as a coalition if they have a responsible party that they're going to name, and then they would currently they would have to maintain an up-to-date list of their coalition members who exceed $5,000 in their own cumulative lobbying compensation expenses. We plan to tweak that particular provision, but in this case, so if a coalition files on its own, it has a responsible party, it's going to list the coalition members. In that situation, the member's contribution to the coalition is not considered a lobbying expenditure for their own reporting purposes. So if I'm a member of a coalition and I contribute X amount, that is not going to be counted against me as a member whether I meet the $5,000 threshold. That's if the coalition files. The other option is if the coalition decides not to file for whatever reason, then each member's contribution does impute back. So that member, any member that exceeds the $5,000 threshold, they can do that either by giving more than $5,000 to the coalition, or they can do that by giving some portion to the coalition and adding that to whatever other lobbying activity they have. If they meet the threshold, that again, that contribution will impute back to the member, and whether that member must file individually.
Carol, and when they do that, just to be clear, if a member is doing it, they would list as a filing expense
Yes.
the contribution that the money that was spent on the coalition. So if someone was trying to look up, the public wanted to determine who was bankrolling the coalition, those donations would be listed in that fashion.
Right. We suggest requiring that member contributed X amount to X coalition, so that hopefully the public can figure out who's contributing to this coalition. So those are the two options. We're recommending revising option one, which is when the coalition files on its own. Instead of, as we currently require a coalition to try and figure out all of its members and whether that member reaches the $5,000 threshold and then list those only. We suggest that that's difficult. We've heard some comments that might be difficult for the coalition to figure out. They might have many members. So we're suggesting revising this, that the coalition that files would have to disclose all paying members, whatever they pay. So you'd be disclosing the paying members. And again, that addresses the concern that the coalition, responsible party of the coalition, cannot figure out, and it's difficult, I should say, to figure out who meets the threshold and who doesn't. So in this case, they just submit, anybody that contributes, those members get listed. We think that's consistent with the notion that the coalition is acting as the contractual client in this situation, easing the reporting burden on the members, but not eliminating the general requirement that beneficial clients get disclosed. We want to know who the clients are, the beneficial and the contractual clients. So we're thinking that would make things a little easier if we do that. So that's the revision we're suggesting. And again, coalitions do have an option. It's not a requirement. They have the option to do one or the other. And depending on what they do, that member may or may not have to have their contribution counted towards them.
And we're going to include unincorporated 501c3s too, correct? I think that's in the reg.
There was a suggestion that, or a comment that the 501c's 5s and 6s were, we are excluding them from the definition. We're going to tweak that a little bit to make sure that all those comments are addressed and make sure that they're not captured.
And we did remove the requirement that it be a corporation.
That was
right. That's what. Right. Thank you.
I have a question. Go ahead. If a member of a coalition does not spend $5,000, either receive or spend $5,000, but they're part of a coalition, when the coalition filing is done as a coalition, are they listed as a beneficial client or as a lobbyist at that point?
They are listed as a coalition member by the coalition. And they are considered
So do they,
if they spend money.
because all members would be beneficial clients.
so if they spend $1.98, but they're part of a coalition because they agree with the principles of the coalition, and then they're listed, do the gift or reportable business or other conflict provisions then apply to them because somehow they're listed as beneficial client and or lobbyist?
Yes.
Yes.
Yes. I mean, the statute regarding the gift rules is very plain about everyone who's identified on a statement of registration, and the Commission has always interpreted that to include the client. If the client is now defined to include multiple beneficial clients, that would be the case. But remember, this situation that you described where the client spends less than $5,000 can already occur today. Once a lobbyist has exceeded their threshold for the year, they're required to disclose all their lobbying activity, regardless of how much each client pays. So this client who hires someone for whatever rate that's less than $5,000 and it would still leave them without a filing requirement for the client, the lobbyist is still going to disclose that client and thereby subject them to these requirements. So this may expand the number of clients, but not the criteria.
So we're considering a person who joins a coalition because they believe in some principle or whatever. They care about the law. Even though they've spent no money, received no money, if other people are working on that same issue with them, even though they haven't hired those other people as retained lobbyists, they haven't directed the other people in terms of what they do, they're still going to have to be listed, and the conflicts and gift bans and reportable business expense prohibitions all apply to them. That troubles me because I've got to say, I don't think the lobbying law was ever intended to cover people who just care about an issue but don't spend or receive $5,000.
If I can, I don't think that's your read of that. The facts you just presented come to that conclusion. Martin, did you want to?
Yeah, the coalition members, again, we're part of a coordinated campaign, and these are paying members. You agree with the actions of the coalition, but you don't spend any money to contribute toward whatever expenditures the coalition has incurred. That does not include you, does not deem you a member of the coalition. You choose to make a contribution to the coalition's activities, it comes with certain implications.
I think the question that Jim was asking is if you have a coalition, of, we'll have a law that reforms baseball, little league fields around the state, and you have, a dozen, 100 different little league organizations that join this coalition. If that individual, I'll choose Columbia County Little League, decides that they're going to sign on to this coalition because they want these changes in the law, but they're not putting any money into it, but they list their name on a letterhead, are they now, I think the question that the commissioner's asking is, are they subject to any kind of limitations now as a client? And if so, is that different than current law? Or is, in fact, current law that they are not hit with any of those limitations and they wouldn't be under our proposal?
Well, there's two issues. The first is under our proposal, no, they would not be required to be disclosed because they did not contribute any funds.
Yes.
The second issue is under current law, as I mentioned, once a lobbyist has exceeded their own threshold, all those activities that they take on, even the pro bono ones, are reportable activities. So that client, if they were in a typical lobbyist-client relationship now, could be disclosed regardless of how much they spent, even if it was a pro bono activity. So I don't, I understand the concern, but I want to clarify that this has been the Commission's policy as well as its predecessors on this issue, and our addition of the coalition reporting option is consistent with an opinion from, I want to say 2002 of the Lobbying Commission, and we're just spelling it out as guidance for the first time.
So I guess
so even if you contribute $5, you get all the Little League players who care, or the softball players because they're adults, who contribute $5 each towards a billboard for a call to action. But all they ever did was play softball and contribute $5. They're going to be listed as lobbyists and maybe kicked out of a job if their particular position, say they're a member of JCOP, they're not allowed to lobby.
So wait, I want to be very clear. We're giving people a choice on how they report. So if they decide to report as a coalition, then the concerns that we're discussing might kick in. But they don't have to report that way. They can report that the members who spend money on lobbying register individually, and then they just have to identify their coalition. Am I right, Martin? Then in that case, none of these issues would come up. So it's completely in their hands how they report, and I would assume that because of the very concerns you're raising, that if it's some kind of small organization with small memberships, they will not report as a coalition. They will have individual members report if they make the $5,000 threshold. They'll do their own filing.
And Jim, those options exist today. Those options exist today. What's been described is the current state of the law.
But if they file as a coalition, maybe I'm missing something, but the way that we're discussing it, I thought that the Little League Association would only be listed as a beneficial client, which is not the same thing as reporting as a lobbyist. They are getting the benefit of lobbying.
If the whole point is, if they are listed on a statement of registration, right, they are subject to the gift ban. And I'm not sure about RBR. I think they would have to report their RBRs, but the thing is that once you're listed on a statement of registration, certain ethical rules do apply to you.
Okay, then I have the same concern.
Right, but you don't have to report as a coalition.
But
you could report differently.
There's no mandate that the coalition that exists be filing as a coalition. If you're dealing with enough organizations like that, this is not mandating that these individuals be subject to the rules. There's an option. Some coalitions for efficiency may want to file in that fashion. But if it decides not, if the coalition doesn't register as a coalition, the public will still, and this is all about the public knowing about the lobbying activity, they'll still learn about the lobbying activity through the individual members who are filing separately. And
because they met the threshold.
Because, and those individuals have met the threshold.
But who makes that decision?
The filing party, Jim.
the big guys in a coalition may want to have the benefits of filing as a coalition. The little guys in a coalition may prefer to go individual because they know they're under 5,000.
Well, they have to choose.
I mean,
Someone has to choose. But
Someone-
the way it's drafted right now, we said you only have to disclose those members who spend more than $5,000, and all the organizations are submitting comments saying, well, we don't know who spends more than $5,000 on lobbying. Like, we don't have a way of tracking that kind of information. So our fix was, so then just disclose the members who are giving you money. We will keep in mind, whatever we do now will be before the commission in December, and then there'll be another round of public comment to make more fixes. But the way it's drafted now, the organizations have a choice, and that is the tricky part, is who's going to make the decision. And I think coalitions are thinking about this issue, and they're aware of the very concerns that we're discussing, and I think that'll be part of their decision-making when they decide how they want to file.
And to reiterate, coalitions have that choice. That is the way the law works now.
Okay, we don't have to nail down the exact language right now, and we could put it off for discussion later. But let me just reiterate publicly what I've said a couple times when I met with Martin, I met with Seth, and I've spoken to one or two commissioners about. And that is generally with regard to calls to action, with regard to volunteers, with regard to board members, with regard to beneficial clients, and with regard to coalitions. I think we should make it clear, or maybe if the commission doesn't agree, my position would be that the lobbying law and the reportable bans and gifts and the gift restrictions and everything were all meant to apply to people who either receive or expend more than $5,000 in an attempt to influence regulations or legislation. They were not meant to include people who just happen to get up on a soapbox and care about an issue and maybe spend $1.98 reprinting circulars. And I think all of these provisions are not clear enough on that in terms of you're not picking up the little guys who just happen to be an advocate citizen or citizen advocate. And we don't have to resolve it today, but it's a major concern for me.
Understood. We'll address it certainly, and we're aware of those concerns. I know that we share those same concerns, which is why we're dealing with not the passive participant or person who's passively receiving. But I think we'll have some language, some concrete language to look at in December, Commissioner, that I think will help address those concerns.
Thank you.
Okay, thank you. Anybody else on this point? All right, Seth. Monica, next item.
Source of funding, I think this is an update, Monica.
Right. So at the last commission meeting, there was some discussion about source of funding and the definition of substantial likelihood in the context of whether or not an applicant can establish a substantial likelihood of harm. We've had some discussion about whether or not you even need a definition of substantial likelihood, but to the extent that a majority of the commission wants to define substantial likelihood, staff is going to recommend that you define substantial likelihood to mean reasonable probability, and it will include that as a proposal in the red line for the December meeting, and the commission can then decide first whether it wants to define substantial likelihood, and if it does, whether that definition is acceptable, and we'll go from there.
Yeah, and just to reiterate, as Monica said, I think the initial question is whether there's even, and that'll be for the commission, we'll tee it up for the commission to consider, whether there's even a need to define the term, given that the term appears in statute and has been applied without definition. But that's all going to be teed up and laid out for the commission in December.
Thank you. Item 5, new and other business. Do we have any? Yeah?
Not apparently on this end, so.
Do you have any? Okay, that's quick. That concludes our public session. I need a motion to enter into executive session, please.
Commissioner McAuliffe has.
Thank you.
Or
Seconded. Thank you.
Commissioner Small, second.
All in favor? Okay, thank you. public session is adjourned.
Stand by, Mr. Chair.
I got a question.
You're back in public session.
Okay, welcome back, everybody. Item 7 on the public agenda. In executive session, we discussed various litigation matters. There was an application pursuant to Section 73(8)B of the Public Officers Law, which was granted. We approved a substantial basis investigation report and settlement agreement, and we approved several investigative steps and discussed several investigative matters. At this point, I need a motion to adjourn the public meeting. Thank you, Commissioner. Second. Thank you, Commissioner Campbell. All in favor? Thank you. It's unanimous. We're adjourned. See everybody in December.
See, my question is if I need the